From the time we wake up, during our time at work, to our return home, we use patented inventions every day. They are almost inescapable and have a large role in how our lives develop. Patents are one of the few rights mentioned within the Constitution itself, located within Article 1, Section 8. So, what is a patent? According to the United States Patent and Trademark Office, the USPTO, a patent is a grant of a property right to the inventor which includes the right to exclude others from making, using, offering for sale, or selling the invention in the United States or importing the invention into the United States. There are three types of patents: utility, design, and plant. Utility patents are for any new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvement thereof. Design patents are given for a new, original, and ornamental design for an article of manufacture. Plant patents are rare and are given to anyone who invents or discovers and asexually reproduces any distinct and new variety of plant. A large amount of you have probably heard the word patent quite a lot recently, especially if you consume any form of media. You've most likely seen it connected with the word troll.
Welcome to the world of so-called patent trolls.
A patent troll is someone that makes their money by filing frivolous lawsuits against companies with the hope that these companies will pay a fee to settle rather than go to court.
Patents. They're basically legally binding dibs.
So our patent and patent enforcement system has gotten to the brink of no return.
And they say, well, you're a non-practicing entity, or you're a patent troll.
Don't manufacture anything, they don't create jobs. Instead, they're siphoning money from companies that do.
About 2/3 of all patent lawsuits in district court last year were filed by non-practicing entities.
All patent trolls typically don't invent anything or sell anything. They simply buy patents and make their money by threatening lawsuits.
In fact, of the 4,700 patent lawsuits filed in 2012, 3,000 were from these so-called patent trolls.
The White House claims during the last 2 years, the number of lawsuits brought by patent trolls has nearly tripled.
Research shows this type of litigation has cost investors an estimated $500 billion since 1990.
So how exactly did we get ourselves into this mess?
Almost a quarter of last year's U.S. patent cases were filed in this Eastern Texas federal court district, Marshall, Texas. Population 24,000.
Teeming with mailboxes for patent troll firms.
It's nothing more than legalized extortion.
But what does the word patent troll mean? You may try to connect it with internet trolls, a fictional monster, or perhaps a practice in fishing. But defining a patent troll is much more complex. Why? Well, there is no definition. At least, there isn't one that is explicitly clear or agreed upon. If you're like me, you may have read somewhere online that a patent troll is some malicious company that amasses patents and begins to go after anyone they can to make a profit. It truly paints the patent troll as an evil force to be dealt with. However, when I first met with my mentor, Mr. Vinicota, I realized my preconceptions about patent trolls were not that accurate. To emphasize this point, which of the following do you believe is a patent troll? A large corporation like GE or Google, a startup company, a holding company, or a university like UT Austin? The answer is all of them, depending on who you ask. Patent trolls are more formally called non-practicing entities, or NPEs for short. NPEs are entities who make patent infringement claims but do not practice their invention, i.e., patent trolls. This is basically a person who takes a patent out on some sort of technological area but doesn't use it themselves. Instead, they sue others who create a product without their permission. Let's look to history for an example. Many people may have heard of Eli Whitney, inventor of the cotton gin, a machine that allowed for people to easily clean seeds out of cotton. Whitney invented the machine in 1793. However, he chose a flawed business model to sell his product. Failing to successfully commercialize the product, to profit from his invention, Whitney instead filed patent suits on those who created their own cotton gins. This allowed for Whitney to gain something before his patent expired in 1807. NPEs, like Whitney, still file suits against those who infringe upon the patents they own. Reforming these laws would change a standard that has been present for years. Not to say that hasn't been done before. Let's now look at Henry Ford. In 1879, George Selden, a patent attorney, applied for a patent that had an extremely vague description that covered all automobiles. This patent allowed for the creation of a monopoly on the production of all automobiles in the United States. Selden and the Association of Licensed Automobile Manufacturers were able to bring suits against any manufacturer of automobiles. Henry Ford had been rejected from the association beforehand. Ford, wanting to produce affordable cars, ignored the setback and kept producing cars until he was sued by the association in 1903. After a long and hard-fought battle involving sputtering cars and huge media coverage, Ford won the case. As Judge Walter Noyes said in his famous decision, "It were even better that the patent had never been granted." Due to the case, the automotive industry flourished, and in 1912 the U.S. Supreme Court adopted rules designed to reduce delays and legal expenses in infringement suits, making it easier to fight and file such cases. Ford's case was able to reform a system that had inherent flaws and promote a growth in business. It may not be a bad idea, then, to look at additional reforms in the patent system to prevent patent abuse. However, before we can make a conclusive decision, we should address the most affected parties of such legislation: businesses. Due to the ISM program, I was given the opportunity to work with my mentor, Mr. Vinicota, and meet a variety of people with differing views on the patent troll issue. One opportunity I was given was to speak with Andrew Campbell and Solomon Ashrafi. Both currently work at NextGen and are former top executives and outside counsel for Metro PCS. Solomon is a telecommunications guru, and Campbell is the powerful in-house attorney. I believe that their opinions are extremely valuable as former workers of a large corporation and now members of a startup company.
My name is Andrew Campbell. I'm an attorney and partner with NextGen Partners. My background, I had a business degree from Southern Methodist, law degree, and a master's in business. I started practicing law in 1990. My practice was primarily focused on business transactions with an emphasis in real estate. Spent 26 years representing primarily institutional real estate owners, developers, investors. During that time, I also represented a telecommunications company, Metro PCS, from its original formation through its first attempt at an IPO. My father-in-law, Roger Lindquist, was the founder and CEO of Metro PCS. Upon the sale of Metro PCS to T-Mobile about 3.5 years ago, he wanted to take a core group from Metro to form what was initially planned as a private equity company focused on interesting or distressed telecom assets, and I helped him structure that, set that up, and we quickly morphed into more of a technology company focused on Dr. Solomon Ashrafi's ideas and technology in the telecommunications space. As you know, my background was not in patent technology law. I was immersed in that pretty much immediately. I hired some of the brightest minds, including Kumar Vinicota, one of the top patent litigators in the country, and he's been helping us and helping our patent prosecutors grow the patent portfolio. And we don't have the resources for an in-house lab, but we have paid for projects at various universities, USC, UTD, SMU, City University of New York, to take some of the technology through the labs, hopefully to get to at least a demo. We feel like we need to go out and create an operating company or companies that would at least give us a platform, and those companies would be actually established, ironically, on existing technology, not our technology, but it would give us the platform then to roll out the new technology that we have. We feel like that's the best strategy at this point.
NextGen is a private equity firm with in-house technology development. NextGen's growing patent portfolio is primarily for commercializing its technological innovations in the near future.
So back in early 80s, I was basically deploying a wireless network, optimizing the first cellular network for Craig McCall. Later, we launched the first PCS network in the United States for American Personal Communications in Washington, Baltimore, MTA. Launched the first GSM network in Germany and France Telecom France. And later I left Washington DC area, came to Dallas area, worked for Nortel and Ericsson. And while I was there, I was on the board of an incubator basically representing Nortel Investments as well as Ericsson Investment later in an accelerator. What these incubators and accelerators did is that they basically had a relationship with venture capital firms locally. Later, I launched a few of my own startup companies, and they were venture-backed companies. And then during that time, I was asked by CEO of Metro PCS to join Metro PCS to launch the first LTE network in the world. And that's what we did in 2010. After we sold the Metro PCS to T-Mobile at the end of 2012, I had to stay at T-Mobile to merge it with, then I had to merge Metro PCS to T-Mobile, and I had to stay there till August of 2013. August of 2013, Rogers, CEO of Metro PCS, and I launched an investment firm, and I'm a managing partner in that, investing in new technologies. And we did a number of investments in new technology companies, but then later we learned that these investments we made, these companies have just incremental innovations, and we wanted to do something a lot more significant and consequential. So we started investing in our own ideas. And with that, we came up with a number of innovations, some 50 to 60 patents, and we're trying to enter the market with a number of ideas as a new operator.
Companies like NextGen need those patent portfolios primarily to avoid being overshadowed by much larger corporations.
In my past 30 years of experience, I have seen companies being purchased by big corporations only to be killed because they posed a threat to them. But they had to acquire them. They had to acquire the patents and innovations and whatnot. But from an entrepreneurial point of view, I think innovations are really important, and the way they do it is they really care about bringing improvements to the industry, right? Whereas big corporations, that may not be their motive.
So, is NextGen a troll? A bigger corporation may very well argue that they are, due to the potential for NextGen to use their patents to prevent competition and cause litigation.
I think the issue really comes down to how do you define, I guess, a patent troll to some degree, and I'll give you, in our specific case, if just because we are currently holding IP that has not been put in practice, we don't have a product, does that put us within the definition of a troll? And I would say certainly not, for a lot of different reasons. First and foremost is that as a growing startup business, litigation is not part of our strategy, first and foremost. Second of all, our technology that we own, we invented. You know, we have not acquired strategically someone else's technology to somehow use that or bootstrap that into a business at the expense of maybe a more mature company. We have every interest to develop the technology.
NextGen is definitely not an NPE, choosing not to litigate using their patents. So, is it fair for a larger corporation to call them a troll?
On the other hand, I think a patent troll, again, is the polar opposite, sort of the core strategy that we follow, and that is just to simply acquire technology that they didn't invent. Maybe even with a specific strategy, they know a particular technology out there, they acquire technology in that same field of practice and use that to extort some sort of settlement or to actively litigate that with absolutely no intention of ever creating a product.
As you can see, being called a troll depends heavily upon opinion and circumstance. Such a vague term being taken too seriously by the media has the potential for harmful consequences, especially for innovative companies like NextGen. Equally important to look at are the legal issues that surround patent troll cases. As mentioned before, defining a patent troll can be difficult for an outsider, and the situation is only made worse by the associated technical terms. As stated by Hannon and Welsh, terms such as non-practicing entity, patent assertion entity, and patent troll are often used interchangeably, and defining these terms for use in legislation or a widely acceptable definition in a way that identifies abusive litigation proves to be a challenging task. The line between these three terms becomes muddled, and the discussion becomes cloudy. I spoke with Sean Su, a partner at Vinicota LLP, to gain a better understanding of the legal side of this problem.
So I have an undergraduate degree from the University of Texas at Austin in electrical engineering. And after I graduated, I went to SMU Law School here in Dallas and obtained a Juris Doctorate, which is a law degree, and have been practicing patent litigation, patent law since then. I'm currently a partner at Vinicota LLP here in Dallas. So my education background was in engineering, and after I graduated from UT Austin, I did a little bit of work with a medical device company, and was around a robotic system for surgical systems. And then around the same time, I went to law school and obtained a legal education. Patent law was kind of a natural fit, just blending my technical background, both from education and work experience, merging that with my legal background. In patent law, we're dealing with new technologies and trying to protect them using legal documents. So that was a natural transition coming out of law school. And after I graduated, I started to work at a firm that primarily specialized in patent litigation. So kind of have been doing that ever since. I guess I would define a patent troll as someone who is exploiting a patent for commercial gain in a way that was not contemplated by the Patent Act.
We've already seen how varied the responses can be to this question. The fact that even legally there's a lot of contention on how to define a troll shows the danger of such widespread usage of the term in the media. The situation is only made more complicated by upcoming government actions.
There are actually a lot of ideas that are floating out there in terms of how to reform the patent system. Congress has looked at several various iterations of legislation along the way. There are a couple ideas that come to mind. One is on the issue of venue, kind of where plaintiffs are allowed to file their lawsuits. Kind of going back to the question earlier about who a patent troll is, one of the issues that Congress is trying to wrestle with is when people pick and choose which court to file in for strategic reasons that start to look like they're abusing the legal system. And in particular, one of them is a jurisdiction out in East Texas that has become known as a patent rocket docket. Basically, the court system out there, cases get filed and go to trial very quickly, which provides a lot of pressure on the defendants. And plaintiffs have latched onto that to try to file cases there as an extra incentive for defendants to pay them money to resolve the legal dispute. So one question that Congress is looking at is how they can try to deal with that potential abuse of the choice of venue, so to speak. Perhaps putting in some rules that companies need to be sued, perhaps in a proximity to where their headquarters are or the nexus of their operations. And there are certain rules that can be put into place to try to force plaintiffs to file in certain venues as opposed to others. And of course, there are going to be some consequences to those changes, and we're going to have to rely on Congress to figure out the best path for that. Another potential change that has been contemplated is a fee shifting, so to speak. So patent litigation, and really litigation in general, is very expensive, and part of that feeds into a desire for companies to try to settle lawsuits to avoid having to pay large amounts of attorney's fees just to handle a case. Where the court system comes into play is, obviously they're interpreting laws that have been passed by Congress and applying them to a particular case. And one in particular for the venue issue that I just mentioned is a Supreme Court decision, or rather a case that's pending in front of the Supreme Court for TC Heartland is one of the plaintiffs. And so that they are addressing this venue question, and that very well, depending on how the Supreme Court decides that case, it may very well change the places that plaintiffs are allowed to file their lawsuits. So we're all waiting to see what the Supreme Court has to say on that.
But why was this issue suddenly garnering a large amount of attention?
It could be anywhere from 3 to 5 or perhaps even 4 to 7 million just to defend one of these cases, regardless of whether you win or lose. And unfortunately, the patent trolls, they are well aware of the cost of litigation. So it creates an incentive for them to perhaps game the system a little bit. They file a lawsuit, and their demand, what they want the other side to pay, is going to be priced at a level that's very competitive with the cost of litigation. So for example, if it is projected to be on average $3 million to defend a case, the plaintiff might ask for, say, $1 million from the company. So from a cost-benefit analysis, then the GC, the general counsel, or perhaps the CEO, the company has to do an economic analysis. Does it make sense for me to pay $3 million to an attorney just to defend this case, and I might still lose and still owe money on top of that? Or do I just pay the other side $1 million today just to have this whole thing go away? And there's a case to be made that it's cheaper to pay the settlement, to pay the plaintiff and have this the whole thing be resolved early on. And perhaps even more egregious, you'll get some plaintiffs who take it a step further. Rather than ask for $1 million, they may only ask for $100,000 or $50,000, a very low amount. And it makes the calculus that much more compelling for the company to settle early, definitely to try to get rid of the case before the attorneys have to do any work on it. Now, what's the incentive for the patent troll? Well, that one particular case, it doesn't sound very lucrative. But if you think of them filing 15 cases, 20 cases on the same patent in the same court system, well then 15, 20 times that 50,000, you're talking again in the millions. And so that calculus, depending on how many people they sue, becomes a volume issue. They sue a lot of people and ask for rock bottom settlement values. And then hopefully for them, the case is settled very quickly. And if, say, they sue 20 companies and 18 of them settle within the first month or so, well, then they've made quite a bit of money without having to do very much work. So from the outside looking at that becomes, it starts to look like an abuse of the patent system, where you have parties filing cases that there may not be a lot of merit to them, but the demand amount that's requested is so low that the company really doesn't see an economic benefit to fighting the case, because you're doing 1 month's worth of work is going to equate, the attorney's fees that they pay is going to equate the settlement amount. So they'd rather just pay that amount, have the case go away, and so then and that creates an incentive for plaintiffs or the patent trolls to kind of abuse that system to try to extract a whole bunch of low dollar value settlements and accumulate wealth that way.
This possible legislation reminds me of tort reform. A tort is a wrongful act or an infringement of a right leading to civil legal liability. A few years back, lawmakers began cracking down on medical malpractice law. Many states soon capped rewards on malpractice cases. In Texas, actual damages are limited to $250,000, and punitive damages are twice that amount. So, if your doctor seriously injured you, possibly preventing you from ever working again, you would only be allowed $750,000 in potential total damages. Obviously, such a large reward for small negligence cases may prompt such a law. But, in my opinion, similar legislation in the patent system spells disaster for American innovation. Say, for example, we put a limit on rewards for a patent infringement in a bid to reduce patent troll occurrences. Initially, it sounds like a great idea. However, companies would soon be able to abuse the system, infringe on patents, and pay a fixed cap amount of damages. But, already having made profits, possibly millions of dollars above the amount given in damages, companies could easily make infringement rewards a cost of business and abuse their newfound power. This system would drastically hurt innovation and startups, like the aforementioned NextGen. Many of you may be wondering, so, what is the right answer? Some companies do file patent suits for malicious purposes, but what can be done to solve the patent troll problem while avoiding harm to businesses and American innovation? In reality, I have no idea. I entered the ISM program with a preconception of what patent trolls were that was entirely influenced by what I had heard in the media. However, I now know that trying to define a patent troll is too complex for a 10-minute segment on the news, or a late-night show, and a high school student's short documentary. Law is an extremely difficult concept to completely grasp. Trying to find a definite answer to this question is exhausting and likely impossible. It is truly a gray matter. I think this situation describes a large amount of law, in a way. Often, who is right and wrong changes on a case-to-case basis. Laws can be interpreted in a variety of different ways, depending on the court. Some laws are extremely vague or have many different loopholes. My struggle to define a patent troll shows how variable the entire profession can be. It's not necessarily a bad thing. A good lawyer can use this vagueness to the advantage of any client. What I've learned this year has shown that a lawyer's job is never black and white. One always has to think on their feet to find creative ways to approach a problem. I am confident, however, that my time at the law office has allowed me to ultimately succeed in my goal of learning more about the field of law. I haven't solved the national crisis, but I am better informed. I would like to encourage all of you watching to do the same. Inform yourself more about topics from a wide variety of sources. Don't let the media fool you into thinking a certain way. Sometimes, it is better to view the world from a more neutral point of view.